Hello and welcome to interest.co.nz. I'm Janae Tibshirani and today I'm joined by IAG's Deputy General Counsel, Seamus Donegan. Thank you for joining us, Seamus.
Pleasure.
As many of you may have heard, the Court of Appeal has released a landmark judgment, which means landlords are now liable for any damage accidentally caused by their tenants. A judge has ruled the owners of a property burnt down after the tenants left a pot of oil unattended on the stove for 5 minutes are liable for the damage. Following a 7-year legal battle, the owner's insurer, AMI, has been left to pay the bill of $216,000. So, Seamus, a big deal for the insurance industry, and no doubt there's some landlords out there thinking, oh no, what does this mean for me? What do landlords need to do to ensure that they are in fact going to be covered in case something like this happens?
Well, the first thing that landlords need to make absolutely certain of is that they have sufficient insurance to meet the cost of repairing any damage that might happen through a careless mistake from a tenant. So in the example of the Holler and Osaki case, there a house burnt down and there were substantial costs involved. Every landlord, if they insure their property, will do it with a sum-insured. They have to make sure and keep up to date with the current building costs to make sure they're not left out of pocket by having insufficient insurance to meet that cost.
Okay, and what about some of those conditions stipulated in policies, things that landlords need to do in order, to meet the conditions of their policy?
Well, landlords are required by most policies to conduct an inspection of the property at least once every 3 months. In the light of this decision, it might be more prudent for landlords to consider doing more frequent inspections just to keep an eye on how the property is being cared for, particularly with tenants who are new and they don't know very well.
Okay, so from a tenant's perspective, there might be some tenants who are thinking, right, I'm no longer liable for anything. The contents insurance, which I took out so that I was covered for personal liability, doesn't really matter anymore. I may as well just give up my contents insurance. What would you say to these people?
Well, first of all, you're insuring against many risks with contents cover. Obviously, the risk of burglary or damage to your own property. But more importantly, the contents policies, by and large, contain a liability insurance, often in excess of $1 million. And if you're living in a property which adjoins another property, then you still are at risk as a tenant if through a careless mistake in the property you're occupying, damage occurs to a neighbouring property, such as in the case of a fire. In that situation, you would still be liable for meeting any claim by the owner of the adjoining property for the damage you've caused, and your contents policy, if it has liability cover, will respond to that liability.
Okay, and that might be in the same way as if you were storing something of someone else on the property that you lived in. So say your friend kept their boat at your property or something like that, and that was damaged.
That's right. You have a responsibility in what we call the law of bailment. If you're looking after property belonging to other people, if you carelessly damage it, you're liable to them also. And a contents policy would respond to that liability. Okay.
What would happen if if an insurer refused to pay out the landlord after the tenant caused a fire? Could the landlord then approach the tenant, sue the tenant and be like, well, look, I'm left with this bill, insurer's not going to pay, you need to fork out?
Well, that's the effect of this judgment. It provides tenants with an exoneration from liability if the property has been insured by the landlord. And that means, for instance, as I said earlier, if there is a shortfall between the money an insurer pays a landlord to repair damage and the actual cost of repairing the damage, unfortunately that bill rests with the landlord.
Okay, and also the excess rests with the landlord?
Correct. Most excesses run at about $550 per claim, and that would be left with the landlord also.
All right, okay. Look, effect on the insurance industry. Obviously, this is a huge judgment. This took you by surprise?
We were surprised and a little disappointed with the outcome.
Okay. What does this mean for you in terms of, how you might need to change your underwriting policy?
Well, at the moment, when we underwrite a landlord cover, we ask many questions about who the landlord is to ensure not only that we have adequately calibrated the amount of cover required, but also we've looked at who the landlord is as a person to look at the moral hazard. Is this person likely to be honest? Is this person likely to care for the property which we're insuring? Now, we're also at risk for the actions of the tenant, and at present we know nothing about the tenants who are occupying these properties. All we have in the policies is a requirement for the landlord to conduct inspections at 3 monthly intervals. Going forward, we may have to start asking landlords to give us information about the tenant who's occupying it, and if necessary, getting privacy disclosures from that tenant so we can find out a little bit more about what sort of risk we're taking on with that tenant.
So could this see the pricing mechanism for premiums change based on the tenant's risk profile?
Correct, and also the factors, most of our pricing is also based on the assumption that we can, if a loss occurs, make a subrogated recovery against the party who's caused it. We no longer can price based on that assumption.
There's been a bit of talk about this, that this will see premium prices go up. Do you think it could?
It could, but it's probably too early. The analysis hasn't really been completed yet to make a determination about that.
What about the pricing of contents insurance? Could this change given that that personal liability, people might not be making as many claims on that part of the contents insurance?
Well, it does reduce our exposure in terms of potential, well, it eliminates the exposure in terms of potential claims by landlords against their own tenants. It doesn't take away anything from the exposure for claims by third parties against those tenants. So again, we'd have to look carefully at how that might affect pricing.
So what is the insurance industry doing now? Is it sort of having to regroup and do a bit of a stock take and I guess see how it's going to move forward further to this ruling?
Well, that's right. I mean, we're reading the ruling very carefully, looking at what parts of the Property Law Act and the Residential Tenancies Act have led to this outcome, and we'll be discussing that internally within the ICNZ and perhaps looking to make representations to government.
What could that look like in terms of what you might put forward to government in terms of changing some of the legislation around this?
Well, there are changes that could be made to the Residential Tenancies Act to make it more clear what the underlying intention was at the time it was enacted.
Sure. All right. Okay, Seamus. Well, thank you. I think we'll leave it at that. There's a lot there for landlords and tenants to think about, and also we'll obviously be watching and looking with anticipation to see what the insurance industry does.
Good.
So thanks for joining us. I'm Janae Tibbs-Shirani and have been joined today by Seamus Donegan from IAG.